Rules Committee, come to order, and thank you very much for joining us today. This afternoon, the second full Rules Committee meeting of the new year will begin, and I first want to begin by commending Congresswoman Rob Woodall and Hastings on their thoughtful and well-executed subcommittee hearing this morning. The subcommittee meeting was very important. It's about issues that are important to United States people and this Congress, and I appreciate their due diligence in that matter. This afternoon, the Rules Committee will consider H.R. 1927, the Fairness in Class Action Litigation Act of 2015. Federal class action rules currently require that a class share questions of law and facts in common, and that the claims and defenses of the representative parties are typical of all those in the class. Despite these standards, some courts have allowed classes to be certified absent a showing that all the members of the class actually share a common injury of the same type and of comparable scope. H.R. 1927 rightly reforms the current federal class action lawsuit framework to require that classes consist of members with the same type and extent of injury, ensuring equality and fairness from the judicial system. This measure also contains language from H.R. 526, the Furthering Asbestos Claim Transparency Act. Additional language would reduce fraud in the asbestos bankruptcy trust system by increasing transparency and ensuring asbestos bankruptcy trust have the tools necessary to identify and combat fraud. I would like to thank the young chairman of the Judiciary Committee, the gentleman from Virginia, Mr. Goodlatte, the authors of this bill, for joining us today, as well as my friend from Tennessee, the gentleman Stephen Cohen. And I'm delighted that you are all here. Before we defer to our witnesses today, I'd like to defer to the gentlewoman from New York, the ranking member of the committee, for any statement she'd like to make. Gentlewoman's recognized.
Thank you, but I'm just happy to have you all here today, and happy New Year.
Thank you very much. In fact, we were bah humbug yesterday because we were here all day and half the night, so it looks like we're all a little bit seemingly better today. We turned over a new leaf today, so here we go. Gentlemen, thank you for taking time to be here. I have no doubt that this will be an interesting meeting just based upon the summary of what I read. I have some background in understanding these cases just by virtue of having a dad and a couple brothers that are lawyers. But I will tell you that you will deal with intricacies today, and we appreciate you giving us a sense of what this is about. And with that said, anything you have in writing will be entered into the record without objection. And please know that our awesome stenographer would appreciate you speaking loud enough where she can get all the words right, because she does a great job. Mr. Chairman, delighted that you're here. Gentleman's recognized.
Well, thank you, Chairman Sessions, for the opportunity to testify today regarding H.R. 1927, legislation that combines two important measures, the Fairness in Class Action Litigation Act and the Furthering Asbestos Claim Transparency Act. Both measures received Judiciary Subcommittee hearings and separately were reported favorably by the full Judiciary Committee. Mr. Chairman, let me first explain the merits of the Fairness in Class Action Litigation Act. Last year, an independent research firm surveyed companies in 26 countries and found that 80% of those who were subject to a class action lawsuit were U.S. companies, putting those U.S. companies at a distinct economic disadvantage when competing with companies worldwide. But the problem of overbroad class actions doesn't just affect U.S. companies. It affects consumers in the United States who are forced into lawsuits they don't want to be in. How do we know that? We know that because the median rate at which consumer class action members take the compensation offered in a settlement is an incredibly low 0.023%. That's right. Only the tiniest fraction of 1% of consumer class action members bother to claim the compensation awarded them. That's clear proof that vastly large numbers of class members are satisfied with the product they purchased, don't want compensation, and don't want to be lumped into a gigantic class action lawsuit. Just recently, a California judicial decision reported that in a class action consisting of over 230,000 people, only two of the 230,000 wanted the coupons offered in the class action settlement. The judge in that case said the case produced, quote, absolutely no benefit really to anybody, end quote. So where is all the money going in these cases? To the lawyers who brought the lawsuits that hardly anyone wanted to be in. Trial lawyers work the system today in the following way. They file lawsuits, for example, against a company that sells a washing machine. Some of those washing machines don't work the way they're supposed to, but most of them do. But the lawyers file a class action lawsuit that includes everyone who ever purchased a washing machine from the company, even the large number of people who are completely satisfied with their purchase. When trial lawyers lump injured and non-comparably injured people in the same class action lawsuit, the limited resources of the parties are wastefully spent weeding through hundreds of thousands of class members in order to find those with actual or significant injuries. That's money that could have been spent compensating deserving victims. Sometimes, because judges don't separate the injured from the non-injured in class actions early enough in the proceedings, they end up throwing out settlements because it turns out hardly any of the class members were harmed and didn't want compensation. Other times, when judges realize they've created an overbroad class, they justify their actions by coming up with novel theories to provide some compensation to people who are entirely satisfied with the product and don't want compensation. Either way, the solution is to direct judges to determine as best they can early in the proceedings which proposed class members are significantly and comparably injured and those who aren't, and to treat them accordingly. That's fair to everyone. The purpose of a class action is to provide a fair means of evaluating like claims, not to provide a way for lawyers to artificially inflate the size of a class to extort a larger settlement value for themselves, and in the process increase the prices of goods and services for everyone. Claims seeking monetary relief for personal injury or economic loss should be grouped in classes in which those who are the most injured receive the most compensation. No one should be forced into a class action with other uninjured or minimally injured members only to see their own compensation reduced. The Fairness in Class Action Litigation Act would simply make clear what currently should be clear to the federal courts, namely that uninjured class members are incompatible with Rule 23b3's current requirement that common claims predominate a class action. The Fairness in Class Action Litigation Act simply provides that no federal court shall certify any proposed class seeking monetary relief for personal injury or economic loss unless the party seeking to maintain such a class action affirmatively demonstrates that each proposed class member suffered the same type and scope of injury as the named class representative or representatives, and that an order issued under Rule 23C1 of the Federal Rules of Civil Procedure that certifies a class seeking monetary relief for personal injury or economic loss shall include a determination, based on a rigorous analysis of the evidence presented, that the requirement in Section A of this section is satisfied. That's it. One page, fair rules, common sense, and wholly consistent with Supreme Court precedent. Mr. Chairman, let me now turn to the benefits of the FACT Act. This legislation helps asbestos victims who must look to the bankruptcy process to seek redress for their or their loved ones' injuries. Too often, by the time asbestos victims assert claims for compensation, the bankruptcy trust formed for their benefit has been diluted by fraudulent claims, leaving these victims without their entitled recovery. Fraud is able to exist because the excessive lack of transparency plaintiffs' firms have forced on the asbestos trust system. Under the current bankruptcy code, plaintiffs' firms essentially are granted a statutory veto right over debtors' Chapter 11 plans that seek to restructure asbestos liabilities. Plaintiffs' firms have exploited this leverage to obtain trust rules that prevent information contained within the trusts from seeing the light of day. The predictable result has been a growing wave of claims and reports of fraud. The increase in fraudulent claims has caused many asbestos bankruptcy trusts to reduce recoveries paid to asbestos victims who emerge following the formation of trusts. The FACT Act, introduced by Congressman Farenthold, combats this fraud by introducing long-needed transparency into the system. First, it requires asbestos trusts to file quarterly reports on their public bankruptcy dockets. These reports will contain basic information about demands to the trusts and the basis for payments made by the trusts to claimants. Second, the FACT Act requires asbestos trusts to respond to information requests about claims asserted against and the basis for payments made by the asbestos trusts. These measures are carefully designed to increase transparency while providing claimants with sufficient privacy protection. To accomplish these goals, the bill leverages privacy protections contained elsewhere in the Bankruptcy Code and includes additional safeguards to preserve claimants' privacy. We cannot allow fraud to continue reducing recoveries for further asbestos victims, and I request the Rules Committee grant an appropriate rule that allows for expeditious consideration of H.R. 1927.
Mr. Chairman, thank you very much. Great summary. Less than 4 minutes. The committee greatly appreciates that. Mr. Cohen?
Thank you, sir. The spirit of Carly Fiorino, I want to tell you, I rooted for Texas A&M this year.
You know, Texas A&M is an institute of higher education, higher learning.
Yes.
And those boys,
And they might have a quarterback
and
left.
those boys, they might.
Tough year. Thank you, sir. The Rules Committee print of H.R. 1927, the Fairness and Class Action Litigation and Furthering Asbestos Claims Transparency Act, combines two bills, each of which are attempts to protect corporate wrongdoers by undermining access to justice and re-victimizing their victims. There's no question that these are attempts to, the result of it is to help corporate wrongdoers, even if part of it is the plaintiffs. And I should say that Mr. Goodlatte, like myself, and two of your brothers, Mr. Chairman, we're all lawyers, and while a lot of his statement was about the lawyers, it's not about all the lawyers, I guess, I hope, because we're lawyers. It's a shame that at a time when our nation faces numerous threats to its well-being, including an epidemic of gun violence, fraught relations between the police and African Americans, criminal justice, and staggering income inequality, the majority has chosen to focus on this bill in the first week of the new year. We closed the last year working together to pass a new transportation bill, end No Child Left Behind, pass tax extenders, and the omnibus spending bill. And I commend the Speaker and Republicans who worked in a bipartisan fashion. But then this year we're starting off kind of on the wrong step. Section 2 of the Rules Committee print effectively makes it impossible for many kinds of class actions to be pursued, denying victims of corporate wrongdoing their day in court. This provision requires that any party seeking to certify a class in a case seeking monetary relief for physical injury or economic harm prove as a condition of class certification that each potential class member suffered the same type and scope of injury. As a practical matter, demonstrating the same scope of injury for each putative class member is impossible to show in most cases, especially when economic harm is at issue. Therefore, this requirement effectively precludes most class actions from being pursued. Moreover, this requirement forces litigation on the merits twice, once at the certification stage and again during the trial, significantly increasing costs to the point where they may dissuade a plaintiff from even filing suit. By foreclosing most class actions, this bill effectively closes the courthouse door for many victims of corporate wrongdoing. Class actions are a critical tool that allows plaintiffs to vindicate their rights in a whole host of matters ranging from employment discrimination and wage and hour disputes to antitrust and consumer protection cases. By making it financially feasible to pursue meritorious claims whose monetary value is otherwise too small to be worth the financial cost of pursuing individually, class actions allowed wrong individuals to receive compensation and hold the wrongdoers accountable. And yes, there are lawyers involved, and if there weren't lawyers, there wouldn't be any changes in policies because the actions do bring about changes, so oftentimes in consumer protection issues, and they act kind of as a private attorney general protecting the public. Current law already allows rigorous requirements on parties seeking class actions to demonstrate commonality of facts and law and typicality of claims and defenses, among other things, in order to proceed as a class. Such requirements, however, have never included a requirement that a plaintiff show that every potential class member suffered the same scope of injury. In fact, federal courts have rejected such a commonality and damages requirement for class certification precisely because such a requirement would, quote, drive a stake through the heart of the class action device, unquote, allowing defendants to escape liability for their wrongdoing, as the conservative Judge Richard Posner has written. Several of my colleagues and I have offered amendments that would exempt various types of class actions from this measure, including those that would help to vindicate civil rights, provide terrorism victims with justice, and hold accountable manufacturers of defective foreign-made products, which might include Chinese drywall, airbags, or other foreign cars manufacturers who have misrepresented Volkswagen. I urge the committee to adopt these amendments. By making it so difficult and costly to pursue class action, Section 2 of H.R. 1927 effectively denies the opportunity for justice for these victims. Finally, Section 3 of H.R. 1927 gives asbestos defendants, the very entities whose products injured millions of Americans, new weapons with which to harm their victims. Section 3 requires a bankruptcy asbestos trust to report on the court's public case docket the name and exposure history of each asbestos victim who receives payment from such trust, as well as the basis of any payment made to the victim. As a result, asbestos claimants' confidential personal information will be released to the public domain for all to see. This sensitive information would be a boon to identity thieves, insurers, potential employers, lenders, and data collectors. Essentially, this bill re-victimizes asbestos victims by exposing their private information to the public, information that has absolutely nothing to do with compensation for asbestos exposure. This is why asbestos victims vigorously oppose this legislation. I said asbestos victims and their heirs, their loved ones, vigorously oppose this legislation. And I'm not aware of a single victim who supports the bill. Last Congress, the administration opposed a bill nearly identical to Section 3 of H.R. 1927. In particular, it warned that legislation's disclosure requirements could be harmful, quote, could be harmful to veterans of the armed forces of the United States who have been disproportionately affected by asbestos, unquote. In sum, 1927 is a seriously flawed bill that benefits those who cause harm to others. Not surprisingly, the bill is opposed by a broad spectrum of organizations, including the NAACP, Consumers Union, Leadership Conference on Civil and Human Rights, AFSCME, the Southern Poverty Law Center, the Military Order of the Purple Heart, the Asbestos Disease Awareness Organization, the AFL-CIO, Public Citizen, and the Environmental Working Group, among others. For these reasons, I urge strong opposition to H.R. 27. Mesothelioma is a terrible illness caused by asbestos and takes people's lives, and it's a very painful, difficult death, not that most aren't, but it's one that could have been prevented. And for those who produce this product that has caused people to suffer mesothelioma, the spectrum should lean over to the victims and not to the manufacturers of the harmful substance. Thank you so much.
Mr. Cohen, thank you very much. Mrs. Fox?
Thank you, Mr. Chairman. I appreciate it very much. I appreciate both of our colleagues being here today, and in the spirit of our keeping our meetings shorter than they have been recently, I yield back the balance of my time.
Thank you very much. Gentlewoman is correct. In fact, the committee has spent a number of hours up here, and we're attempting to move through expeditiously, as the Judiciary Committee may say. I have better words, but we're going to try and do that, and you'll see that as an activity today and as we move forward. Mrs. Slaughter?
In the same spirit, which my sister from North Carolina, I also will pass on questions this afternoon.
Thank you. Does anyone in the on the Democratic side have a question for either of our witnesses? Judge Hastings, you're recognized.
Thank you very much, Mr. Chairman. Mr. Goodlatte, I'd like to ask you if, under this measure, knowing that you would be very familiar with Brown versus the Board of Education, do you think that the victims in that particular case could be certified as a class action under 1927?
I do, because I think that the criteria for a class action would be very comparable across the board. And if someone is being discriminated
We're not kidding. We're not kidding. He thinks you're kidding. You think we're kidding.
Case where one person has a broken washing machine and somebody else has a perfectly fine washing machine, and they both get lumped into the same thing, where one has been harmed and perhaps seriously harmed, and the other has not been harmed at all.
Well, what about if injury occurs and one person has a broken hand and the other person has a broken foot? Are those the same type of injuries that would be contemplated?
Yes, this does not contemplate that injuries have to be equal. It only contemplates that they have to be within a scope that is comparable. This is governed by long-standing case law that is based upon Supreme Court decisions, and it is based upon the practice that is followed in most of our federal courts today. The problem is that there are a number of federal courts who do not follow it, and this inconsistency is what this legislation is intended to address.
You're very familiar, I'm sure, with Rule 23. And you also are very familiar, I would believe, with the judicial process and the fact that Rule 23 is being tooled through that process as the legislation previously had allowed for in setting up this particular measure. That said, is it unwarranted to let that process play out in the courts or to see what the Judicial Council will come up with under Federal Rule of Procedure 23?
To a certain extent, yes, but not to the extent that the process has been abused by people bringing class actions, whereas in the example I cited, you just, with a broad brush, say, hey, everybody here who ever brought a washing machine, we're bringing you into this lawsuit. That needs to be addressed and determined early on, and not waste the resources of the court or the parties to the case.
I think that's what the Judicial Council is looking at, the kinds of things that you talk about. It wouldn't surprise you to know that I file class actions as a lawyer. It also wouldn't surprise you to know that I certified or did not certify in most cases as a federal judge class actions. The numbers are not there to show that this is a problem so manifest or that we would preclude ordinary American citizens from an opportunity to address corporations and others that may have done great harm. And that's the ultimate question that I put. What impact do you think this legislation would have on everyday Americans who don't have access to teams of lawyers but have nevertheless been victimized by corporate wrongdoers?
Well, you know, if you watch the ads on television, there are lawyers who go and actually sort through and find the people who are actual victims rather than just using this broad brush approach. And I suspect that what you'd have happened in those circumstances is a greater concerted effort upon the part of the lawyers seeking to represent a class to find out who actually belongs in the class and who does not. And they are simply taking a shortcut to avoid that when they bring in everybody into a class, whether they've done any due diligence or not, to determine whether or not the people should be a part of that class.
When I listen to you, and I'm raising a question that I don't know the answer to, and perhaps you or Mr. Cohen may. Assume for the moment that a class has been certified, either a settlement, very few of them, I might add, as you well know, go to trial, but a settlement has occurred, and the distribution has been set up, and all of the funds for distribution, as you point out, you may have, I certainly have received those little letters, and they look like junk mail, and there's too much on them, and so you throw them away. But that said, what happens to the funds that are not distributed? The lawyers have a percentage, I believe, of what they would have court approval to receive. But what happens to those funds that aren't distributed?
Well, I think it depends upon the amount of the funds in question. If there is not sufficient money to fully recompense the people who have been truly harmed, then this legislation would assure that more of the funds would be available for the people who truly were harmed. If, however, everybody who's truly harmed is not shortchanged, then I suspect that the amount of the settlement might be adjusted by the court to say, well, we don't need this much money. And that, of course, you could say, well, that benefits the corporation that did this, but it also benefits every other consumer who buys goods from that corporation or in that marketplace, because you're not having as great an expense.
Well, I'll have an opportunity tomorrow. I think I'll be managing the rule, and I'll have a lot more to say about it. But I just don't understand why this bill mandates burdensome reporting requirements for the asbestos bankruptcy trust, but not impose similar requirements for the companies that exposed Americans to asbestos. And that's one aspect of the legislation that I think really does require the members to pay close attention to. But I appreciate your views on it. Obviously, you know mine are different. All right. Thank you, Mr. Chairman.
Thank you very much, Judge. Mr. Polis, do you seek time? No, thank you very much. Does any Republican seek time? The gentleman from Alabama, our legal counsel, Mr. Chairman.
I would not go that far. Mr. Chairman, I handled a lot of these lawsuits from the defense side when I was in private practice. And as I recall, under Rule 23, one of the things you have to show if you're seeking to get a class certified is commonality, the commonality among the class members. So I guess I'm wondering what's the difference between the requirement for commonality under Rule 23 and the requirement in this statute for the same type and scope of injury?
Well, we think that this makes clear what some federal judges have not found to be clear in the commonality requirement by making it express that one of the factors of commonality is that these injuries be of similar scope. And as I said in response to the gentleman from Florida, most federal courts do follow that practice. But unfortunately, there are a number who do not. And so this is an attempt to address that fairness issue.
It's sort of a statutory definition for Rule 23 of what commonality typically is construed to be anyway.
I would say that that's correct. It enhances the understanding of the court and the attorneys as to what's expected of them when they bring a class action.
And does it add anything to this that you say that each proposed class member meets same type and scope? Is that different from what Rule 23 requires now? Because Rule 23 now, you're just making the statement that this is what the class is defined as. You don't typically know exactly who's in that class or who may be in that class, particularly at that point in time. So does this change the proof any under Rule 23 for a certification procedure?
I think that it changes the due diligence that's required of the attorneys bringing the class action suit to come into the court and early on meet this criteria rather than be allowed to certify a class that includes a lot of people who were not harmed.
So they'd have to be more specific in the way that they define the class in order to meet the burden that each person meets the scope, same type and scope.
Correct.
I'd just say, based upon my practice, at least the plaintiff's lawyers that I've dealt with, I felt like they're already trying to meet that standard anyway, and the judges that I dealt with were already expecting that standard to be met. But you say that there are some cases out there, some judges out there that haven't been living up to that standard, and that it seems to be appropriate for us to define it by statute on top of what Rule 23 and the practices around the country.
That's correct.
That's all my questions. Thank you, Mr. Chairman.
Thank you very much, counsel. Appreciate that. Gentlemen, thank you very much for being with us. Mr. Polis hopes you come back often, Mr. Chairman.
We'd be delighted to, Mr. Chairman.
We have legislation which this committee very much looks forward to you bringing back to us during the year. Serious discussions. I know that the Judiciary Committee has many serious and interesting issues that you are responsible for within your jurisdictional element. But this committee vigorously debates and looks forward to not only the things that you bring to us, but the hopes and expectations for this being a great a great year, and we thank you both for taking time to do that.
Well, thank you, Mr. Chairman. We always feel welcome here, and I can assure you the Judiciary Committee will be back again.
Yes, sir. Thank
No
you
doubt
very
about
much.
it.
Thank you.
Yes, Steve, thank you. The next panel would come, I noticed Mr. Johnson is here. Mr. Johnson, if you'd please come and take a chair. I noticed the gentleman from Pennsylvania, Bucks County, Pennsylvania, Mr. Fitzpatrick is here. And I do not see Mrs. Waters, who we anticipated, and I do not see anyone else. So we will go ahead and get started. I believe the committee members are delighted that you both are here. We do appreciate a summary, a quickly getting to the point and quickly allowing this committee to ask questions of you. We will be precise in that manner. Both of you, I hope, will please leave whatever you have in writing for our stenographer. Mr. Johnson, you're recognized.
Thank you, Mr. Chairman. My amendment would remove the scope and economic loss language from H.R. 1927, the Fairness in Class Action Litigation Act of 2015. Class action suits are beneficial to consumers because they level the playing field for the little guy, consumers, working people, and small business owners. Class actions enable the weak to unite and seek justice in a court of law against a strong, wealthy, powerful, and politically well-connected corporation, just like the ones whose campaign contributions control who gets elected to Congress. An individual who has been injured or defrauded by a multinational corporation can join up with other individuals hurt in the same scheme and in the same way, and by means of a class action lawsuit, hold that corporate wrongdoer accountable in court. A small recovery, on the other hand, by a single plaintiff does not get the attention of the corporate wrongdoer. But if you aggregate a number of small claimants together and you ring the bell against a wealthy corporation with a plaintiff's verdict in court, it sends a powerful message and forces the corporation to start doing the right thing. A small claimant going it alone against a powerful corporation that comes to court with an army of high-powered, tasseled shoe-wearing, silver briefcase-toting, $900 an hour lawyers.
Mr. Johnson, if the gentleman will please stop for just one moment. This committee is a very serious committee, and we are able to accurately, I believe, understand when you talk about the merits of the case, but we do not wish or choose to be a part of a diatribe about a philosophy or about things which might drive one way or another anybody's philosophy. What we're interested in is the facts of the case as it relates to an amendment or your support therein of this legislation. And I might say to both of our witnesses that are here, it is my hope that both of you will provide this committee with the ability to effectively understand what we have in front of us, the basis, the facts of the law, or the legislation. And I would say that to the gentleman at this time. Mrs. Slaughter, do you have anything you would choose to say? Thank you very much.
Well, now,
Yes, sir.
Mr. Chairman, if I might, I would apologize for offending the
You
chairman.
did not offend me. I'm simply trying to let you know that this committee has spent a great deal of time where we try and look at the basis of the facts of the case, not about a story therein.
Well, and that point is well taken,
Thank
Mr.
you.
Chairman.
Gentleman's recognized.
Just simply trying to lay out the background for the necessity of this amendment.
Well, I agree with that, but the gentleman has tried to describe who gets elected to Congress, who supports those people being elected to Congress, about the intricacies of those things. And this committee, I speak on behalf of the committee, is interested in, as you as an important witness who would come here, talking to us about a piece of legislation, not about extraneous matters. And I would ask the gentleman to please confine his remarks to the committee so that we're able to do our work also. We spent sometimes excessive amount of time up here, and sometimes it is completely in line that we have to ask a lot of questions that may extend the time, but that we try and focus on and have very exemplary members of this committee, including a former federal judge, including a biologist, including a PhD in economics education, including a gentleman who himself is a very bright lawyer, and a lawyer a physician of enormous capacity. And we do look to each other to try and resolve those matters extraneous to legislation as we apply them. So I would simply say to the gentleman, politely again, I am going to ask that you please confine your comments directly to the legislation.
Well, thank you.
Therein. Thank you.
Thank you.
Recognized.
Thank you, sir. And I would just conclude by stating that the scope and economic loss language in the bill unfairly requires plaintiffs to prove the merits of their case twice, once at the certification stage and once during the trial on the merits of their case. And by prohibiting a court from certifying a class action unless all class members have suffered exactly the same type and scope of injury as the named class representative, if that's the requirement, then this bill would let the very powerful corporations that Americans need to sue in class actions effectively prevent any future consumer class actions from proceeding. The scope language would eviscerate many claims, including those stemming from defective products, fraud, price fixing, civil rights code, antitrust, mass consumer breach of warranty, business loss claims, and theft of basic lost wages, as it is virtually impossible for large groups of consumers or businesses to prove that their harm is exactly the same as the harm sustained by the named plaintiff. So, for example, the owner of a vehicle that has been recalled with a steering defect should not have to also be mangled or killed in a catastrophic accident the way the named representative was in order to be eligible for certification in a product defect class action. Pursuing such actions is very complicated and requires significant resources not available to the individual consumer, but justice for the little guy is possible when injured parties band together in a class action lawsuit. Class actions make it economically feasible for these individuals and small businesses to seek justice against multinational corporations with significantly more resources. The scope and economic loss language contained in H.R. 1927 would make these procedural hurdles even more burdensome and make the justice for the little guy impossible by slamming the courthouse door in the face of those who need it most. The scope and economic loss language should be stricken, and I would ask for your support in this amendment, at least in making it or ruling it germane. And with that, I yield back.
Thank you very much, Mr. Fitzpatrick. Welcome to the Rules Committee. Delighted that you're here with us today, and the gentleman's recognized.
Thank you, Chairman,
Yes,
and members of the committee for the opportunity to speak to the amendment that I've offered. It's an amendment to the Class Action Fairness Act, which rights a wrong by ensuring fairness to victims of unsafe medical devices by allowing their cases to be heard by the courts, which is a right in this particular case I want to talk about today that is being denied. While many medical devices prove life-saving, we know that some can cause harm and have devastating consequences on patient health. In fact, I can guarantee that each and every one of us has constituents who are harmed by an unsafe device. Whether it's a power morcellator, a pelvic mesh implant, a redesigned blood clot filter, or the permanent contraceptive device, eSure. And so I think everyone would agree when a medical device is not safe, we should work to remove it from the market. And those harms should have recourse through the judicial system. And that's how it works for a majority of the medical devices. But right now, if a medical device is approved by the Food and Drug Administration through its strictest review, which is called the pre-market approval or the PMA process, then that device manufacturer is completely shielded from liability should that device injure patients. A 2008 Supreme Court decision unfortunately held that current law preempts these types of consumer claims. While the PMA is supposed to be the FDA's gold standard of safety, I think we all understand that even the most well-intentioned federal bureaucracies are not perfect. And it's obvious this process has failed in some instances, yet for those impacted, there's no option. And here is just one example of how this injustice is playing out right now. The permanent contraceptive implant, Essure, was granted PMA by the FDA in 2002. Essure is a metal coil made of nickel, which is implanted into a woman's fallopian tube, causing scarring of the tissue in order to prevent pregnancy permanently. And it's marketed as a non-surgical procedure. But in the 13 years since Essure was given a stamp of approval by the FDA, tens of thousands of women have reported issues with the device, including debilitating pain, heavy bleeding, extreme weight gain, punctured organs, loss of teeth and hair, and immunological reactions. In some cases, the device has been responsible for the death of women and the death of their unborn children. To date, 25,000 women have joined together in an online community to share stories of pain and suffering caused by Essure. Every day, this group connects women living through their own nightmares. I've talked to many of these Essure sisters, and I've read hundreds of their stories, some of the most tragic being the cases of the device failing to prevent a pregnancy. If the device is implanted and a woman still gets pregnant, those metal Essure coils become a death sentence for the unborn child, the sharp metal device acting like shrapnel in the womb. Tragically, that was the case for a young child, Ariel Grace. Ariel's mother, Christiana, had the Essure device implanted after giving birth to her third child. She was told Essure was a terrific birth control option for her, a permanent procedure with no incision that could be done right in the doctor's office. But the device failed, and she was with child. And on June 8th of last year, Christiana gave birth to Ariel Grace nearly 3 months early. Sadly, Ariel never took a breath. She was stillborn. The Essure device caused placental abruption. Christiana suffered with postpartum depression and decided to undergo a hysterectomy to remove the Essure coils, to remove the fear that losing another child could happen to her if the Essure remained inside her body. And while I have an opinion on the safety and effectiveness of Essure after reading stories like Ariel's, I'm not here to convince you of that one way or the other. But I do hope to convince you that these women deserve the chance to tell their story, not just to the media, not just to the FDA, not just to us as members of Congress, but to the courts that they're currently blocked from. My amendment won't guarantee those harmed will win in court, or that they'll even have a legally sufficient case that could go to a jury. But it will clear the way for legal recourse that is currently denied. That's the right of every American, not the least of which would be those who've been harmed by devices that were designed to help them. So I'd ask that my amendment be ruled in order, that these women be given a voice, that these women be given an opportunity for justice. I appreciate the time before the committee. Happy to answer any questions.
Mr. Fitzpatrick, thank you very much. Mr. Cole, Mr. Chairman, is there any Republican that seeks time? Any Republican seeks time? Thank you very much. Is there any? Gentlewoman's recognized. Yes, ma'am.
A minute, because Congressman Fitzpatrick and I are working on the morcellation together, and I'm pleased to do that. I'm co-sponsor that, and we'll co-sponsor this amendment as well. I appreciate you're doing it. Morcellation has really caused an awful lot of grief in my district, and I appreciate the fact that we're addressing it. It is, and certainly they do have a right, I would hope, against the manufacturers for false information and things that did not work. So thank you, Congressman. I support your amendment.
Thank you very much. Is there any, Judge Hastings? Judge, thank you. Judge, thank you. Gentlemen, thank you for taking time. If you'll please make sure that you leave anything you brought in writing for our great stenographer.
Thank you, Chairman.
Mr. Chairman.
Our goal is to report the rule before the votes. This committee, as such, will stand in recess, but you would anticipate, I believe we have votes around 5 o'clock, so I would anticipate that we would call us back quickly before that period of time. I'm sorry, is any
You on very expeditious way, which delights me. Thank you.
Yes, ma'am. I felt like I received a good bit of support from the women under threat, of the women of this committee. And
We said that Virginia and I.
if my wife is watching this, or my mother, I'm in trouble. You know, let me say this. This committee and our members hear an extraordinary number of ideas, and you're in this committee because it excites you. But I do admit that there can be times at which we need to move more rapidly than others. And
20 hours a week is too
and
much.
I believe that I received a swift kick in the can from the women of this organization last night, and it was reinforced again today. So if there's any question about that, you can call my office. I'm sure my press secretary will put a good statement out
Just
about
don't
that.
mess with Two Mountain Road.
No, ma'am, I do not intend to. Thank you very much. And I thank the committee for attempting to back me up in that. They knew what I was doing. And if you didn't, come see me and I'll explain it to you. As my dad used to say, if you don't understand it, call me and we'll pray together that you do. We'll be in recess subject to the call. thank you very much to the members and the staff for allowing us to come back together. The chairman now being received the motion, Vice Chair of the Committee, the gentlewoman from North Carolina, Dr. Fox.
Thank you, Mr. Chairman. I move the committee grant H.R. 1927, the Fairness in Class Action Litigation Act of 2015, a structured rule. The rule provides 1 hour general debate equally divided and controlled by the chair and ranking minority member of the Committee on the Judiciary. The rule waives all points of order against consideration of the bill. The rule makes an order as original text for the purpose of amendment, an amendment in the nature of a substitute consisting of the text of Rules Committee Print 114-38 and provides that it shall be considered as read. The rule waives all points of order against that amendment in the nature of a substitute. The rule makes an order only those further amendments printed in the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment, shall not be subject to a demand for division of the question. The rule waives all points of order against the amendments printed in the report. The rule provides one motion to recommit with or without instructions. Finally, Section 2 of the rule provides that a vote on any motion relating to the disposition of the veto message and the bill, H.R. 3762, may be postponed through the legislative day of January 25th, 2016, as though under Clause 8 of Rule 20.
Thank you very much. You've now heard the motion from the gentleman from North Carolina. Is there discussion or amendment to that?
Yes, Mr. Chairman.
Gentlewoman's recognized.
First, I want to say I'm sorry that Congressman Fitzpatrick's amendment wasn't made in order because it's a very serious issue. The women have been damaged by the devices he was talking about. Second, I wanted to ask them to strike Section 2 on the grounds that we have never said we're going to postpone a vote on to override a veto before the bill has even been passed and vetoed. We don't know why that's attached to the rule. I have your word that there's absolutely nothing wrong with this except that we will be in session 3 days the next 2 weeks, correct? But if a veto message should come while we are in the 3 days, in both of those 2 weeks, that we would, as normal, take it up for a vote. Did I state that correctly to you? All right. We were very much concerned to see it in there, and we would like to make a motion to strike, and we would like a vote on it.
Okay. I'm going to try and take 1 minute to offer what I consider to be a sincere rebuttal to a sincere question.
All right.
I looked in the House Rules and Manual. I didn't do it by myself. I cheated. Staff did it. Page 54. Nothing new. Nothing new. Page 54. Under what might be Section 108 under veto, consideration of a vetoed bill in the House. And I'm reading this, page 54, if anybody would choose to do it. It is possible, although not inevitable, that a bill shall be returned with the objection of the president shall be voted on at once. That means you can, but it doesn't mean it has to be. But it would be voted on
It
at
pretty strongly
once.
says that's the way to do it.
There you go. Well,
Right.
what if we're not here?
I don't think that, I can't imagine that the president would return it.
Well, we don't know.
That he had vetoed it when we're not here to deal with.
You know what? I didn't call him. I admit that.
Well,
Nor am I
that's
trying to
beside
even-
the point. The point that
But-
I made is it is very unusual that
Shall
we
be
would
voted
pass a rule
on at
today,
once.
but
Shall
we-
be voted on at once.
Right.
Well, how about if you're at your retreat? And we, Rules
He'll probably
Committee,
be there with us.
well, might be
I
in
don't know.
spirit.
Look,
You know what I'm
let's
saying.
not-
We're-
let
but we're
me
trying to just be
restate what
reasonable.
I'm concerned about here, is that we've never done this before. You are asking us to vote out a rule dealing with a veto message on a bill that hasn't even passed.
Well,
So I really think.
lots of things we do ahead of time because we don't know. But all I'm trying to do is look at you. You asked me a darn good question. And I tried to be as honest and sincere. And the gentleman, Mr. Halprin, who also guides and helps me, and I looked at him because he came in the office.
I
and
do
looked
trust
at him.
Mr. Halprin.
You do?
Yes, I do.
Well, a guy from Altoona, Pennsylvania is a good guy, but here's my point.
But I don't
Louise,
see.
we're simply
There's no
saying
point to be made that you are.
that a
feeling
bill
we're dealing
returned
with a
with
bill
the
that hasn't
objections
passed
of the
or
president
vetoed.
shall be voted on at once. And all we're saying is, since we're going to be gone and you're going to be gone and we're going to be in pro forma session, we don't want somebody to take
Pete, let me
that
say
and make
again,
the
what you're
argument.
doing here is dealing with this, how you're going to dispose of a bill that's passed and vetoed when that hasn't even happened.
Well, I'm gonna be a good guesser. I hope the president will sign the bill.
I'm sure you do. Yeah.
I
all right.
do.
Uh-huh. Oh,
So
yeah,
if you're
we've
suggesting he's gonna sign the bill, I'll be for that.
I think we ought to, it's my intention that the legislative process should be, follow the rules, and the rule would be the man would veto it and send it up here. The idea that you would want to do that ahead of time, that you would be voting maybe on January 25th.
Well, you know what?
Because there will be 6 days in those 2 weeks.
Look,
in
if he
which
does
we will
that,
be
then it
in-
doesn't matter.
All right. Well, I
So
still
that's
want,
the
I
other,
still would
then the
like.
comma is, and Louise, I believe, and Mr. Halpern was just as sincere, I believe that we would attempt to follow what it says here when it came here if we were in.
Well, you have certainly given me your sincere word about that, but
So,
I just
that's
object,
what we're
I
doing.
object to
Yes,
it most
ma'am.
on the grounds that I just don't think it follows regular legislative
Okay, well,
procedure, and I'm concerned about that.
you know-
And not what you read on page 54, I think really didn't particularly deal with.
Well, what it says is that when the bill's returned, upon the objections of the president, there should be voted on at once. That means Congress can't go do what you think I'm gonna do, hold it. But I'm trying to say, we could be in pro forma session. We could be here doing business, you could be here doing business, and somebody would say, it
Well,
says
let me
right there,
think
I've gotta
ahead.
do it.
Let me think ahead as you're
So we're just trying to
thinking
say
ahead,
it could be
and tell you
postponed.
that I cannot imagine that the White House would send a vetoed bill up here when we're not
Well,
in session.
I-
And I think we could, I just don't see the necessity for
Okay.
this.
Does anybody
So
else
let
wish
me
to
make a
be heard?
motion to strike.
Yeah.
Anybody else?
No,
want- Jim?
I'll support what the ranking member says. And I think that the cautionary note here is that what we're doing here is unprecedented in the sense that I don't think we've ever put this in a rule before. And again, as the ranking member pointed out, which I think kind of underscores kind of the farce of what is going on with this healthcare bill, is that we haven't even voted on it yet, and we're already putting this in a rule which is unprecedented.
Okay.
So
Yeah, if the gentlemen feel better, I can postpone this meeting till later tonight, and we can come back, and we can, if that's what you'd like to do.
No,
I'm trying to get
it
through
won't
this
change,
thing.
it won't change the outcome, but it doesn't, it also underscores, doesn't change the fact.
I think it
that
sets a bad
that never in a
precedent.
rule have we ever done this.
Well,
And
now,
so-
and I admitted,
Right,
I
so
believe
that-
you, that's
and I think
probably
so
correct.
that's the point I'm trying to make, and I have nothing else to say, and we can.
Well, I'm trying to be straight up to both of you, and if Judge Hastings, would you like to be heard on this point?
No, Mr. Chairman.
Thank you, sir. Mr. Polis?
I think, you're breaking ground with new ideas for rules. So, it's always exciting when I get to see our committee trying to do something new and different, because I know that when we're in the majority, that'll be an idea that we can then
We
put to
can
good
do,
use.
right?
There you go. Well, let me just put it this way. I think I've explained our intent and our purpose in the most forthright and honest way, and I think I dealt with the language and even pointed to the substance of the page and the section.
Yeah, Mr.
And it
Chairman.
does say that.
Mr. Chairman.
Yes, sir.
With your permission, I'd ask unanimous consent that the entirety of consideration of a veto bill in the House be made a part of the record.
Without objection. Thank you very much. Is there anyone else that wishes to be heard? Thank you very much. Does the gentlewoman, did she make?
Yes, I did. I had a
Was that
motion
a-
to strike.
All right, we now have the Slaughter Amendment. Those in favor of Slaughter Amendment signify by saying aye.
Aye.
Those opposed, no. No. Noes have it, noes have it.
Roll call.
Gentlewoman asked for a roll call vote.
Ms. Fox? Ms. Fox, no. Mr. Cole? Mr. Cole, no. Mr. Woodall? Mr. Woodall, no. Mr. Burgess? Mr. Burgess, no. Mr. Stivers? Mr. Stivers, no. Mr. Collins? Mr. Collins, no. Mr. Byrne? Mr. Byrne, no. Mr. Newhouse? Ms. Slaughter?
Yes.
Ms. Slaughter, aye. Mr. McGovern?
Aye.
Mr. McGovern, aye. Mr. Hastings?
Aye.
Mr. Hastings, aye. Mr. Polis? Aye. Mr. Polis, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will report the total.
4 yeas, 8 nays.
Motion's not agreed to, not agreed to.
Mr. Chairman,
Yes, sir.
I have an amendment to the rule. I'm sorry.
Yes, I'd like to ask unanimous consent, if I may, to insert the statement of administrative policy into the record.
Without objection.
And Mr. Chair, I have a statement I'd like to submit to the record from Ms. Sheila Jackson Lee.
Without objection.
Chairman, I have a statement I want to submit for Congresswoman Maxine Waters,
Without objection, I'll be.
and I also have an amendment.
The gentleman's recognized.
I have an amendment to the rule. I move the committee grant H.R. 1927 an open rule so that all members have the opportunity to offer amendments to the bill on the floor.
Thank you very much. Discussion.
Yes, Mr. Chairman.
Gentleman's recognized.
In regard to that motion, I'd just like to say that the rule provides for consideration of the bill and under a structured amendment process. It makes in order 10 Democratic amendments and more than three-fourths, which are more than three-fourths of the amendments submitted. The rule also includes a provision allowing the chair to postpone these votes upon related consideration of any veto message, which we've already discussed. And it's a straightforward rule, and I think the ones that's been now offered are being made in order, and I think that's sufficient for this. And would urge a no vote on this motion.
Yeah. And if
Well,
I
thank
could-
you, gentlemen,
Yeah,
for
and if I could just say,
clarity.
maybe, so my friend can understand what an open rule, why sometimes open rules are important. This, because it's not an open rule, if somebody is watching the debate tomorrow or comes up with an idea tonight, they'll be prevented from offering an amendment. And in the spirit of, openness, and that's why this is being offered. So that's, I understand it's a structured rule. If it was an open rule, I wouldn't be offering an open rule amendment.
Let me, Mr. Chairman, if I can follow on
Gentleman's
the
recognized.
discussion very briefly and respond to my friend, Mr. Collins. What happens, the way we proceed, you would normally expect that with the Rules Committee having posted the time requirement for specific legislation, that members generally and arguably are all advised that they could offer amendments. But I've been here when we had open rules, and I've been here when we operated under the 5-minute rule, and you would be amazed at how many ideas members have that never came up here to this committee. And I just wanted you to be made aware of that. So the fact that 10 amendments are made in order does not mean that Congresswoman X or Y is mindful of what we are doing.
And I appreciate my friends if they would, from Jill, Mr. Chairman, I think I have no problem with that. Coming from a legislative body in Georgia, I'm very familiar with what open rules are, and I think this side is very familiar with what open rules look like because that's what our appropriations bills look like, open, not closed, as has happened in other administrations. So we're very familiar with open rules. I just wanted to make clear, just as restating what this said and moving on with the amendment.
Yeah, Mr. Chairman, I'd like to ask for a vote.
Can I, may I further debate that? I just had to, my colleague from Georgia mentioned that there's been appropriation bills with an open process brought to the floor. And we had a subcommittee of this committee, which I happen to serve on, had a hearing about this topic earlier. And my great frustration has been, yes, we have that open process, but then the amendments that actually pass disappear into some dustbin in some back room somewhere because these appropriation bills never become law. They get lumped together in some omnibus without the amendments that we did our work on the floor. So it feels like, we're here at midnight or 11 o'clock under an open rule putting things in the bill, and they're bipartisan. Some of them pass with 2/3 of this body, and then they disappear because of some closed-door discussion somewhere. So that's a great frustration, and hopefully this committee in its area of original jurisdiction will be able to work on some reforms to make sure that the open amendment process for appropriations actually means something. And I yield back to the gentleman from Massachusetts.
And I would just say, we didn't do all the appropriations bills, having said that, but I will share with the gentleman a memo that will help him understand that this has been the most closed Congress in the history of our country. So I will insist that we have a vote on this open rule.
I would say to the gentleman, thank you very much. I do believe that this committee, among all the members, has a chance to see some of the frailties and some of the advantages of what we do. I've attempted now in the last few weeks to make sure literally that I announce the rules on the floor in front of everybody. We've tried to do it in an open process in front of people. We want to send out emails. We want to make people aware. We're trying to open up the process. And I believe that, as the gentleman from Georgia said, we had a good number of members that did choose to come and participate in a good number of amendments that we took very seriously in that endeavor. So I appreciate the gentleman's viewpoints, and I take them very seriously, and I appreciate the gentleman making those points. We now have an amendment on the floor, and the gentleman's asking for a vote on that, the McGovern amendment. Those in favor signify by saying aye.
Aye.
Those opposed, no.
Ask for a roll call.
Noes have it. Gentleman asks for a roll call vote.
Ms. Fox? No. Ms. Fox? No. Mr. Cole? No. Mr. Cole, no. Mr. Woodall? No. Mr. Woodall, no. Mr. Burgess? Mr. Burgess, no. Mr. Stivers? No. Mr. Stivers, no. Mr. Collins? No. Mr. Collins, no. Mr. Byrne? No. Mr. Byrne, no. Mr. Newhouse? Ms. Slaughter?
Yes.
Ms. Slaughter, aye. Mr. McGovern?
Aye.
Mr. McGovern, aye. Mr. Hastings?
Aye.
Mr. Hastings, aye. Mr. Polis? Aye. Mr. Polis, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk report the total.
4 yeas, 8 nays.
Amendment's not agreed to, not agreed to. Further amendment or discussion?
Yes, Mr. Chairman.
Gentleman's recognized.
Mr. Chairman.
Yes, sir.
I have an amendment to the rule, and I move the committee make an order and give the necessary waivers for the amendment to H.R. 1927 by Representative Fitzpatrick, number 11, which would clarify that patient harmed by an FDA-approved medical device are not barred from having his or her claim heard by a state court. And Mr. Chairman, I think Ms. Slaughter made the argument, but I just wish to add, Mr. Fitzpatrick's testimony here was very, very compelling, and he cited to an awful anecdotal bit of information that I thought would, if any amendment was made in order, would allow that the body here would make that one in order. And I do think that, for example, there are members whose amendments were made in order, and I make no argument about them not appearing before the Rules Committee, but I think there ought to be a little bit of value to the persons who do come up here and make their presentations. And it's kind of, at least to me, a dissing of the persons who come here and the ones that don't get their amendments made in order, and then somebody like Mr. Fitzpatrick with a very serious amendment that would probably be defeated, but at the very same time should have had an opportunity to be made in order. So I offer that amendment, Mr. Chairman.
The gentleman is offering an amendment. Further discussion. I would reply to the gentleman that this committee many times relies upon people filing their bills and us going through a deliberative process that you go through on your side, that we go on our side, and then there's some way of a way in measuring of the germaneness of these amendments. This was not germane.
I have trouble with that. Why?
Well,
we're dealing with class action litigation and actions against medical devices that cause harm to a class of people that could be certified. Why would it not be germane? I'd have to ask the parliamentarian about
if
that.
if you'd like to let me get that answer, I'll be very pleased.
All right.
Stand by just one moment.
Waive it.
Yeah.
Well, it's outside the jurisdiction of the Judiciary Committee. It's in the jurisdiction of the Energy and Commerce Committee.
Well,
because it deals with the FDA.
okay, then.
Which is a surprise. I didn't know the reason either.
The request that I made to you, Mr. Chairman, as we always do with our amendments, allows that we give the necessary waivers for an amendment. And in this case, I think we could exercise appropriate action by waiving the germaneness provision. That said, I just thought his testimony was compelling, and I thought of all the things that I heard here and things that I said regarding class actions, if there was ever a case where we need to have other members vote on it, then I thought that this was it. And I'll leave it at that, Mr. Chairman.
Thank you very much. You know, I am not on that committee of jurisdiction. I have been through some intricate, as you have, more intricate circumstances than I have, but when you go through an FDA trial, there are a number of things that are presumed, assumed, and looked at in that process of getting the benefit of that being approved.
I don't want to prolong it, Mr. Chairman.
Then I won't.
But when the FDA approves something, the bureaucrats that we talk about all the time, rightly, that make those kinds of decisions are immune.
Evidently, they
can't
are.
be
I did not
sued.
know that.
Yeah.
I did not really understand. I'm beginning to understand much of this stuff. So I'm saying, you've been through much more litigation than I have been. I've heard of a good bit, but you have lived through it. And all I'm saying is, I accepted the substance that it's someone else's jurisdiction, and I assume that the gentleman, Mr. Fitzpatrick, will see me on the floor quickly. And perhaps that's true. By the way, I think this is not his first time on this issue. As I recall, it has been done. Okay.
Mr. Chairman,
I-
could we vote on the motion?
Well, as a matter of fact, I think we ought to get to that. We're now through our discussion. Would you consider, so we're going to consider your amendment? Those in favor of the Hastings amendment signify by saying aye. Those opposed, no.
No.
Noes have it, noes have it. Gentleman asks for a roll call vote.
Ms. Fox?
No.
Ms. Fox? No. Mr. Cole? Mr. Cole, no. Mr. Woodall? Mr. Woodall, no. Mr. Burgess? Mr. Burgess, no. Mr. Stivers? Mr. Stivers, no. Mr. Collins? Mr. Collins, no. Mr. Byrne? Mr. Byrne, no. Mr. Newhouse? Ms. Slaughter? Ms. Slaughter, aye. Mr. McGovern? Mr. McGovern, aye. Mr. Hastings? Mr. Hastings, aye. Mr. Polis? Mr. Polis, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk report the total.
4 yeas, 8 nays.
Amendment's not agreed to, not amended to. Further amendment or discussion, seeing none, vote will now be on the motion from the gentlewoman from North Carolina. Those in favor signify by saying aye. Aye. Those opposed, no. No. Ayes have it, ayes have it. And according, gentlewoman asks for a roll call vote.
Ms. Fox? Aye. Ms. Fox, aye. Mr. Cole? Mr. Cole, aye. Mr. Woodall? Mr. Woodall, aye. Mr. Burgess? Mr. Burgess, aye. Mr. Stivers? Mr. Stivers, aye. Mr. Collins? Mr. Collins, aye. Mr. Byrne? Mr. Byrne, aye. Mr. Newhouse? Ms. Slaughter?
No.
Ms. Slaughter, no. Mr. McGovern? Mr. McGovern, no. Mr. Hastings? Mr. Hastings, no. Mr. Polis? Mr. Polis, no. Mr. Chairman?
Aye.
Mr. Chairman, aye.
Clerk report the total.
8 yeas, 4 nays.
Motion is agreed to, and accordingly, the gentleman from Georgia, Mr. Collins, will be handling this for the Republicans,
And Mr. Hastings.
and Judge Hastings will be handling this for Democrats. I would expect that we do not expect any other meeting, do not anticipate or expect us to have another meeting during the week. Thank you very much. Welcome home. I hope everybody has a safe week, and I hope you're sleeping inside tonight. Thank you very much.